Good afternoon, and thank you very much for having me here. As a non-lawyer, there's no tougher audience than a room full of lawyers who are at best sort of watching your every word to pounce on the factual inaccuracies and misinterpretations that you might come out with, and at worst, are paying no attention to what you say whatsoever. In response to this situation, I've got two tactics. The first is I'm going to broaden the scope of the discussion a bit and to focus more on the policy questions that have been touched on today. The second tactic is not to have any slides, which at least gives me the potential for plausible deniability afterwards. So I'm going to consider proactive obligations from a regulator's perspective. That is, as a strategy that might be adopted by bodies with regulatory functions to influence intermediaries' activities to achieve policy goals. And I'm also going to talk briefly about some of the other regulatory approaches that I think are now emerging, which I've described in my Oxford research as procedural accountability, and consider whether these might represent a more fruitful regulatory strategy, at least in certain circumstances. I think I'd better start, though, by clarifying how I'm using the term regulation, which isn't consensually defined in the literature. In a paper from 2016 entitled "What is Regulation?", Barack Orbach describes various usages that go back to the drafting of the US Constitution. To regulate was to adjust by rule or method, to direct, including prescribing certain measures, to mark out a certain course, to order, or to command. So direct, prescribe, order, command. This is perhaps the most intuitive concept of regulation as a form of command and control. That is the laying down and enforcement of rules that dictate what individuals, companies and groups may or may not do. And Blacks defines regulation as the act or process of controlling by rule or restriction. Sometimes, though, there's a looser and more flexible sense of regulation. Anthony Ogus wrote a classic study of regulation published in 1994, in which he defines regulation as the law by which, quote, the state seeks to direct or encourage behaviour which would not occur without such intervention. And the UK's Better Regulation Commission also defined regulation widely as any government measure or intervention that seeks to change the behaviour of individuals or groups. And more recently, Chris Hodges, in his work on ethical business regulation, is concerned with, quotes, how public regulators in a contemporary Western European democracy should seek to affect the market behaviour of traders. Regulation should be viewed, he says, as producing desirable behaviour by the people involved. So this second sense of regulation recognises that the ultimate goal of regulation is not the rules themselves, but the behaviour they induce, and that there are many ways of inducing preferred behaviour, not just directing or commanding. Now, the main way of regulating online intermediaries in Europe, as we've heard throughout today, and particularly in the last section, is notice and action regimes. And I think these are regulatory in both the senses that I described. First, of course, they are directive in the sense that they oblige intermediaries to review items of content that are notified to them and to take them down if they break the law or the intermediary's own terms of use. But notice and action regimes have also encouraged proactive behaviour that's not directly mandated by the law itself, although scope for it exists in the e-commerce directive. And in setting norms about intermediaries' responsibilities, creating a body of cases, a sort of informal case law within intermediaries' own decision-making, and making intermediaries bear the cost of judging cases, notice and action regimes have helped to encourage intermediaries to take voluntary steps to reduce the supply of harmful or illegal content, even where notification does not take place. In other words, by requiring intermediaries to act after the fact on notified content, notice and action has induced before the fact activity by intermediaries to seek and screen out illegal content before it ever surfaces on their platforms. Even though, as we've heard, the e-commerce directive prohibits states from putting intermediaries under obligations for general monitoring for illegal content. Now, Notice and action regimes are extensively used. Facebook said in 2017 that it deleted 66,000 posts per week on average over a period of 2 particular months that had been notified to it as hate speech. In total, it receives 2 million requests for content removal per week. YouTube receives 1.4 million content flags per week, and Google gets about 3,000 requests per week under the right to be forgotten, asking for a little over 10,000 URLs to be delisted. And there were some more helpful stats in the last session about the cumulative impact of those requests. But the key thing, I think, is that those numbers are dwarfed now by the volume of content that's removed by intermediaries' automated tools. Facebook said at an event recently that 99% of the content it removes, it identifies itself. It wasn't entirely clear from the context whether that was a rhetorical 99% or a real data point, but nonetheless it's revealing. And Google is also reported to have said that 83% of the extremist content it takes down is removed by automated tools, absent any notification. And I'm saying all this partly as background to what I think is the drift towards proactive monitoring obligations that we see in current regulatory debates. On the one hand, there's a widespread view, that notice and action isn't working as effectively as some feel it ought to. And on the other hand, that technology, including the kinds of automated detection tools that I've mentioned, now allows for a more effective preemptive response. And if that technology exists, I think policymakers are asking, why not impose it as a matter of regulation as opposed to voluntary action by intermediaries? So the European Council said last June that it expects industry to develop new technology and tools to improve the automatic detection and removal of content that incites to terrorist acts. And those calls were echoed by statements at subsequent G7 and G20 summits. As I mentioned, and as we've discussed already today, the e-commerce directive always recognised the possibility of voluntary measures to block content pre-notification. Recital 40 says that the directive should not preclude the development and effective operation of technical systems of protection and identification and of technical surveillance instruments made possible by digital technology. And the duty of care provisions in Recital 48 allow for the possibility of member states to impose requirements to detect and prevent certain types of illegal activity. But I think there's a trend, and again we've heard about some of these developments earlier today, a trend towards embedding these positive obligations in regulation. Lorna talked about the draft revised AVMS directive and its obligations on video sharing platforms to put in place appropriate measures to protect minors from harmful content and protect all citizens from incitement to violence or hatred. The Copyright Directive makes some analogous proposals, specifically with respect to content recognition technology. And the recent recommendation from the Commission on Illegal Content says that measures to tackle terrorist content should include automated proactive measures, and clarifies once more that taking those measures does not automatically lead to the intermediary losing the benefit of liability exemption. Now, it's not for me to take a view on the merits of these specific cases and regulations, which many people here are more expert on than me. But the question that I think is relevant from a policymaker's perspective is whether these proactive obligations, as currently framed, and indeed the notice and action regimes which have existed hitherto, are effective as a form of regulation. And I would argue that by and large they're not effective as a form of regulation, particularly in the broader sense that I described at the beginning. Better regulation principles, for example those developed in the UK over 20 years ago, require that regulation is proportionate, that the state only intervenes when necessary, that remedies match the risk and costs are identified and minimised. But it's very rare that assessments are carried out of the scale of the risk and impact of illegal content of different types, the costs of monitoring technology and human moderation relative to the benefits, and the impacts on competition between platforms. In fact, I say those assessments are rare. I'm not aware of any such systematic assessment of the regulatory impact of notice and action regimes. That may be my ignorance. And if people are aware of them, I'd be interested to see them. And there certainly are costs of these regimes, not just to intermediaries themselves, but to industry and society more generally. Proactive monitoring, I think, could work well for illegalities that can be detected easily, cost-effectively, and precisely. But these conditions don't often apply to the kinds of content that we might be talking about here. Hate speech, even copyright infringement, extremist content. These things are heavily context-dependent, difficult to identify, and reasonable people may reach different views about whether the content is, in fact, illegal. So errors and dispute are inevitable. There's a high risk of false positives, of the inadvertent suppression of legal and socially valuable content, and the tougher the sanctions on intermediaries, the higher the risk, because sanctions skew incentives only in one direction. There are generally no penalties for inadvertent removal of legal material, but in some of the legislation that we see now, of course, there are very significant penalties for failing to remove illegal material. Accountable regulation also requires decisions that are subject to public scrutiny and capable of being appealed. But proactive obligations delegate legal and ethical decision-making to private companies. And as we've heard, they often are awarded a generous degree of freedom about how they make those decisions, with few regulated guarantees of transparency. So measures of that kind tend to concentrate platform power rather than constrain it. Proactive obligations can also create barriers to entry by requiring new competitors to develop complex and expensive detection tools, potentially early in their growth. And the costs of doing so are very substantial. In effect, it could be argued that YouTube's Content ID technology is a competitive moat against other video sharing platforms who can't afford to develop such effective tools. And of course, on the other hand, these automated detection tools may not work very well. They may not be as good at differentiating legal from illegal content as we might like to believe. And even if they are, they may drive harmful content into less tractable environments rather than remove it entirely. So I suppose the point here is, in a sense, a technical policy-making one. We want legislators to be careful about making vague law that empowers third parties to decide what is and isn't legal content. But the risk with proactive obligations is that it's the opposite of careful law. It throws problems over the wall to technology firms based on unproven assumptions about technological capabilities, little visibility of intermediaries, policies and processes, and no systematic approach to oversight, impact assessment and review. If there have been, as I believe, relatively few evaluations of notice and action regimes by public authorities in terms of systematic assessment of their impacts, it's even more concerning that proactive obligations might be introduced with the same limitations. Now, I think the risks that I've mentioned are sort of frequently discussed in these policy debates and perhaps well understood. But there is another set of problems with both notice and action regimes and proactive obligations, which I think get a bit less attention. And that is the single-minded focus that they represent on harmful content and the role of intermediaries in distributing it. And consequently, a general lack of consideration of intermediaries' potential role in spreading the benefits of online communication. The regulatory debate and the legislation that we've discussed today is framed in terms of harms and constraints. But there are also policy questions about how intermediaries can enhance media diversity, create safe spaces for online exchange, promote digital inclusion, facilitate the discovery of content that meets public service objectives, and so on. Now, the measures that we've discussed today are largely silent on whether intermediaries do in fact have those roles to play, and whether their incentives in running their communities are aligned with those objectives. So, to my mind, proactive obligations have significant, in principle, drawbacks from a better regulation perspective. But I think there are some other approaches that can be identified, and none of them without their challenges. And these approaches are driven by the recognition that intermediaries do have a vital role to play in securing internet benefits and mitigating risk, but that individual intermediary initiatives, self-regulatory initiatives, may be insufficient to achieve legitimacy and accountability. So the question I think policymakers in some areas are starting to grapple with is how does one seek to engage intermediaries in managing policy opportunities and risk in a more transparent and accountable way, without kind of micromanaging their approach to particular content harms. And clearly this is not a straightforward task. I don't think the things that I'm going to talk about now are necessarily inconsistent with notice and action regimes or proactive obligations. In fact, in some areas they may be more complementary. So there's two broad sort of camps of activity that I think we can see going on. The first is multi-stakeholder initiatives, which is a comfortingly inclusive, if somewhat woolly concept, characterised by collaboration between platforms, policymakers, civil society and other interested parties. Some examples, I think, have been deemed to be successful. The Internet Watch Foundation, perhaps, is the best known, certainly the longest-lived example, I think. More recent examples include the Global Internet Forum to Counter Terrorism, or the Partnership on Artificial Intelligence to Benefit Society. These initiatives are not generally known for the brevity of their names. The model tends to be voluntary, either industry-led or significantly industry-driven, but they often originate in government pressure to act. Such action is the price of avoiding more intrusive regulation. Andrew Pudifat, who chairs the Internet Watch Foundation, has produced quite a useful checklist of success factors for these initiatives. Good multi-stakeholder models have a clear remit, a precise definition of the problem or opportunity to be addressed, and a shared goal, independent governance, the ability to make binding decisions about content or sources to be blocked or promoted, and transparency about performance relative to goals. These, of course, can be applied to potentially positive uses of technology as well as responses to harmful content. Now, one advantage of the multi-stakeholder approach is the ability to take a global approach to global problems, or alternatively, and potentially, solutions brokered in one jurisdiction can be exported to others. But of course, this can cause problems where differences in legal frameworks and social expectations exist between jurisdictions. These initiatives can be slow and wasteful, and with large numbers of senior people spending significant amounts of time trying to make consensual progress on difficult issues. The price of consensus can be limited action. And of course, the processes themselves can lack transparency and accountability, and there are concerns about a number of these initiatives that they're more focused on the interests of the participants than they are the public policy goals which are supposed to drive them. So the second sort of group of efforts, and this is the final area I'll touch on, I bracket together slightly inelegantly as forms of procedural accountability. And the characteristic of these is a greater focus on the processes by which intermediaries make, implement and enforce rules about information markets, rather than the content itself or the tools that they use to manage it. And in these approaches, policymakers set standards for intermediary procedures. So that could be standards for problem definition, assessment of impact of chosen solutions, stakeholder engagement, moderator training and support, dispute resolution, appeals processes, transparency reports, so on and so forth. And the idea is that this provides a way for intermediaries to achieve legitimacy through procedural means, that is by developing processes, policies and systems that are consistent with principles of good governance. And these strategies might work well where disputes about policy are inevitable, desired outcomes are hard to specify, it's hard to assess the impacts of algorithms and platform features. In these cases, following due process might be a better indicator of responsible decision-making by intermediaries than decision outcomes themselves. Now, there's lots of this that goes on of a kind voluntarily. We heard about the transparency reports from Google and others in the previous section. Ethics committees, there's a sort of raft of these sorts of voluntary initiatives. But I think the more interesting aspect is the procedural turn in some current policy and legislative proposals. So, for example, in the German network enforcement law, which has been widely criticised for the very significant sanctions for not taking down content quickly enough, criticisms which I think are entirely justified, but there's another aspect to it, which is that companies can avoid those sanctions if they refer notified content to an approved industry self-regulator, which is quite a common model in the German regulatory regime. And these self-regulatory bodies have to meet certain procedural standards and be approved by the German Ministry of Justice, but the state itself doesn't participate in content decisions. And that I think is an interesting model. Of course, there are procedural requirements in the Copyright Directive and the recommendation on illegal content. So I'm not saying that those are absent from European policy. I won't say more about those now. One UK example in this context, which I think is interesting if flawed, was the Code of Practice on Search and Copyright that Google, Bing and rights holders signed last year, which people here may have been exposed to and had some involvement in. The procedural role played by government was in convening the parties, working to agree measures of success and strategies to prevent infringing material appearing in search results, and to put in place an approach to evaluation and reporting with the Intellectual Property Office commissioning research to track progress. So there's a sort of interesting procedural element there to the role of policymakers in bringing the parties together to an agreed approach. Whether it is an example of these initiatives themselves displaying good governance is another question, because the actual Code of Practice itself, I don't think has ever been formally published or launched. You can only find it as a result of a Freedom of Information request, or last time I looked, you could only find it in response to a Freedom of Information request online. And there's no requirement of redress for websites who can show they've been wrongly classed as infringing. So standards of transparency and appeal and redress need to be upheld and all stakeholder interests represented. So to wrap up, these procedural measures, of course, don't resolve the difficult issues at the heart of online content regulation. They don't make it easier to reach a balance between competing rights and interests. They don't solve the difficulty of differentiating legal and illegal content and the importance of context. But by establishing due process, and by due process I think that means independently defined and independently validated, intermediaries may be able to legitimise their wider content policies and practices that extend very much wider than that which is required by current regulation. I suppose to wrap up, I've tried to describe what I see as the limitations of notice and action and proactive obligations from a regulatory perspective. Relying on them, I think, as the primary means of regulating online content intermediaries is unlikely to be effective. But other approaches are available, and I think to my mind, from a regulatory perspective, what is lacking is more focus on the procedures by which requirements are implemented, as well as on the substance of discussions. Now, I'm not going to even attempt to answer questions here about how these procedural requirements might be enshrined in law. That's both beyond my expertise and the work that I've done so far. But that, I think, is the direction that we should be encouraging policymakers to move in. Thank you.